I listened to him, and I was very disappointed, to say the least. What Nana Adukufo, lawyer Nana Akufo, former member of parliament Nana Akufo, president of the country, has done is just to use generalities to try to support the case of the Supreme Court. No one has said that parliament is above the law. No one has said that. In fact, like I've been saying, Nana Akufo, the president, knows very well that the limitations on the powers of parliament are contained in the constitution. And if somebody alleges that parliament has contravened those limitations, then the Supreme Court can strike down the acts or omissions of parliament in contravening those limitations. And those limitations are of three types. There are substantive limitations on the exercise of power of the parliament. There are procedural limitations on the exercise of powers of the president, and there are institutional limitations on the exercise of powers of parliament. The procedural limitations are if the law says that parliament has the power to do this, but in doing that they must do it a certain way. That way is the procedure they have to adopt in exercising that power. If they fail, refuse, or neglect to follow that procedure, you can go to court and strike it down. Institutional limitations. Clear example. Parliament shall not pass a law affecting chieftaincy without consulting the institution of chieftaincy. So if Parliament proposes to pass a law that affects the institution of chieftaincy without first consulting with the chieftaincy institution, that law will be struck down because they have an institutional obligation to follow, to consult with that institution. Now, the substantive limitation, the clearest example I can give you is Article 3 of the Constitution, where it says that Parliament shall have no power to pass a retroactive legislation. So it's substantive. So if Parliament passes a law that takes retroactive effect, you can go to court and strike down that legislation as being in contravention with the Constitution. We all agree that. And that is what the exercise of the supervisory jurisdiction, if you want to call it that way, of the courts in terms of the enforcement of the provisions of the Constitution as regards Parliament comes into play. What is an issue? What is an issue? And that we understand the Supreme Court to have done is to move into Parliament and determine how Parliament must conduct its own business. And I say, and I will continue to say, that is wrong, that is unacceptable. The Supreme Court has no jurisdiction to pry into Parliament to see how Parliament conducts its business. Senator, the Chief Justice empanels the Supreme Court. Has anybody ever asked the Chief Justice the criteria for empaneling the Supreme Court? How did the Supreme Court, the Chief Justice, arrive at the conclusion that Justice Dube, Amekakshi, Ashikote, Mariam Owusu, and Yoni Kulendi must sit on this matter? How did it come? We can't ask because that is the internal administration of the institution, of the judiciary institution. You can't ask that question. It is beyond the jurisdiction of any establishment to ask that question. And that is what we are saying, that the president clearly got it wrong. The president clearly got it wrong. Now, the president was in Parliament. And I was in Parliament with him. I remember ever rising on a point of order to stop him when he was a foreign minister and arguing when the Nigerians, there were disturbances in Tamale, and he sought to paint a picture as if that those disturbances were not on the scale that was happening. I was on a point of order. Because clearly he did not appreciate and was not well informed of what was happening in Tamale. So I have met him in court before. I've not done a case with him before, but I've met him in court before. And he knows me in court as well as in Parliament. And so he's gotten it wrong, totally wrong. And as an institutionalist, I will not subscribe to any institution of state determining the internal order and how the business of any other institution or arm of government should be conducted. Who has ever asked the president on the conditions, the circumstances under which he appointed the chief of staff? Who has ever asked this president? Because it is beyond our jurisdiction. We can ask that question. Or why he has decided to appoint two deputy chiefs of staff. It is beyond our distance. It's beyond. We can ask that question. Similarly, the standing orders of Parliament determine how Parliament must conduct its business. That is out of Parliament. That is out of the judiciary. That is one question the judiciary can ask. And it is stated in before in the Attorney General clearly by Justice Sowa. That terrain is beyond the jurisdiction of the Supreme Court. In any case, Sana, has it crossed your mind that when the justices of the Supreme Court are nominated by the President in consultation with the Judicial Council, they are submitted to Parliament for vetting? Because Parliament is the elected representatives of the people. How can an unelected arm of government determine how the elected representatives of the people must do their work? Tell me. How is it possible? If Parliament or if the justices of the Supreme Court want to amend the standing orders of Parliament with the greatest respect to them, all they have to do is to resign their positions as justices of the Supreme Court, go and contest elections, come to Parliament and raise the issue of the standing orders of Parliament on the floor of Parliament for it to be debated and a decision taken. But they cannot surreptitiously, indirectly determine how the standing orders of Parliament must work. They cannot. They have no such jurisdiction. Lastly, the standing orders of Parliament itself constitutes the Speaker of Parliament as the exclusive authority on the meaning and intent of the provisions of the standing orders. Exclusive. So when the Speaker determines, interprets the standing orders of Parliament, it's final. You cannot challenge the interpretation of that order in any court of law. So what are they doing? Sarah, what are they doing? How can the Supreme Court be a purveyor of constitution? They, with the greatest respect to them, they should have declined jurisdiction to interpret it. They should have. Because you see, like I said yesterday to you, there's a legal maxim. In Latin expressed as quando aliquid provitor ex director provitor e par obligo. Whatever you cannot do directly, you can't do indirectly. That's the meaning. So if the court has no jurisdiction to pry into the affairs of Parliament directly, how can they have that jurisdiction to do it indirectly? Striking down Article Order 1093 is an indirect control of Parliament. That's what they have done.
Alaji, just one question, then I'll let you go. But I'm also thinking that the Constitution gives particular powers to members of Parliament. One of them, I believe, is the right to vote on an issue before the House. Now, is the question really about how the House is run, or the question is about somebody's or a deputy speaker or elected member of Parliament's rights to hold that vote even after he is elected for an office? And if the latter is the case, why can't the Supreme Court look at it?
The Supreme Court, first of all, let's get matters clear. Sarah, There is no provision in the standing orders that says that a deputy speaker of parliament cannot vote. There is no such provision. We know as a matter of extract knowledge, everybody knows the constitution, the standing orders makes it very abundantly clear that the speaker is the only person in the scheme of things in the speakership who is not a member of parliament. In fact, the constitution and the standing orders even go as far as saying that the two deputy speakers to be elected to run the business of the house must not come from the same party. The only condition that is in the standing orders, that is not in the constitution, and that again buttresses the point that it is for the administration, it is for the business of the house. That is why it is not in the constitution. If you look at Article Order 109, 109, 1 and 2 are the reproduction of constitutional provisions. It is only 1093 which is not a reproduction of a constitutional, and that must have been done with a purpose. That must be done with a purpose. So, the only time a deputy speaker or a member presiding in the absence of the speaker and the deputy speakers cannot vote is when that person takes the chair, when the speaker or a member presiding takes the chair. That is the only time the standing order says you cannot vote. Why? Because the speaker is to maintain order and discipline in the house. The speaker is to show fairness and neutrality in the house. The speaker's chair must be insulated against petty partisan politics. And I read you, the speaker cannot be a referee and a player at the same time. That is the only reason. That is the only time. So when the speaker is in the chair and the deputy speakers are on the floor and there is a motion to be voted on, there is no provision in the constitution or the standing orders that prevents the deputy speakers from voting. It is only when they ascend the chair. So that exception proves the rule that no provision in the constitution bars the deputy speaker from voting, except when they ascend the chair, when they take the chair. So, and the constitution, the standing order is clear. The original vote of a member of parliament is one of the attributes of a member of parliament. The right to vote, to exercise a vote, is an attribute of a member of parliament. So the standing order 1093 is so clear that look, a deputy minister or a person presiding will lose that original, and he uses that word, original vote when he is in the chair. So in interpretation, in construction of legislation, you have to look at the intent. Is the intent clearly expressed? Yes. The answer is yes. It's clearly expressed. You have to go for the purpose. Why we do so? It's because we want to insulate that chair against petty partisan politics. And that is buttressed by the constitutional provision, which says that the deputy speakers must not come from the same party. So even if a speaker, if a parliament, a majority has overwhelming majority in parliament, the requirement is that a deputy speaker, one of the deputy speakers, must come from the minority party.
Well, Alaji, thank you for speaking to us. But I when I keep listening to the leadership, which you know very well, on the minority side, because at this point in time, I think it was the general secretary of your party who said yesterday that it may be a short-lived victory, but they seem to see it as victory. The members on the other side, they seem uninterested in fighting this particular decision. Your side seem to be, they do not really know. They don't want to disrespect the Supreme Court. At the same time, their disagreement as to how do they respond if a deputy speaker attempts to vote. Because clearly, Juwais yesterday, immediately after the judgment, I think sort of started a premature celebration, sort of. How do you expect that they should react to this?
Nobody can celebrate this decision if you are a true institutionalist and if you believe in the Montesquieu's principles of separation of powers, and you believe that all the arms of government are co-equal in terms of power, and the only limit on the excess of powers of the various arms of government is what is captured in the Constitution, then you cannot support the decision of the Supreme Court. The Supreme Court's decision is an apparent manifest interference into the business of Parliament. It's not the powers of Parliament, the business of Parliament. They are two different things. The business of Parliament is different from the powers of Parliament. It's just like saying that the Supreme Court can in future say that when Parliament reconvenes, because we are a secular state, they should not offer prayers, because that prayer violates the rights of other persons who do not have religion. So can the Supreme Court do that? But the standing orders say that at the commencement of business, this is what happens. You have to say prayers, you have to look at the votes and proceedings, that's mark the register, and all those things. So you see, so that's the business of Parliament. And there are stated times in the standing orders where certain things can be done. So if you wake up at the beginning of the prayers to move a motion, a half-hour motion, they will tell you that you are out of order. Because the order of business in the House is determined by the standing orders. If you want to remove a motion to bring the conduct of a member of Parliament or any person who, in your view, breaches the privileges conferred on a member of Parliament, or somebody has acted in a way that brings Parliament into disrepute, there is a time of the standing order. There's a time within which you can do that. You can't do that at any time. So it's the business of how the business of the House is conducted. So the majority as well as the minority must be protecting their terrain. If it is ended order 84 or so, or is it 184? One of the provisions or on order of the conviction or the standing orders tells you how you can amend the standing orders. There's an amendment provision in the standing order. So if it is the view of Parliament that standing order 1093 doesn't achieve the purpose or is obtuse, there's a procedure for amending the standing order. And so people must not celebrate this. I feel very, very disturbed that the Supreme Court is now making incursions into how Parliament is run. I just feel very... Nana Akufo-Addo has said that everybody should respect the Constitution. Even that was the highest, Article 11 of the Constitution. That's the highest law of the land. That's a guru norm. All laws of this country must be consistent with the Constitution. That's the guru norm. That's the basic law of this country, the Constitution. But Nana Akufo-Addo was in Parliament. And the standing orders of Parliament, the Constitution, and Parliament itself share the same age. So when the Nana Akufo-Addo realized that Order 1093 is inconsistent with the Constitution, he was once upon a time the chairman of the a ranking member of the Constitutional, Legal and Parliamentary Affairs Committee. Once upon a time, Nana Akufo-Addo. So when did he realize that standing order 1093 is inconsistent with the Constitution? Does it have to take a Supreme Court for him to discover his courage of conviction and firm up his mind on that provision? I mean, he shouldn't have been speaking on this matter. I've been scanning the papers today, and I see that he's the biggest supporter of the Supreme Court decision. Obviously, you know why? Because that releases. That's why the minority leader has said that that's judicial support for the e-levy.